right, we'll go ahead and start with our introductions for now. Just start with a few housekeeping things, and then I will introduce our panelists. Hello to everyone who's just joining. We really appreciate you coming today and taking the time out of your schedule to join us in this Section 1557 checkup. We previously held an initial session about this in May, and as we know, things are changing rapidly. We even have some updates that came in today that will be included in this discussion. So we are really looking forward to unpacking more information about Section 1557 and what it means and how we can make the best use of it and make sure that we are in compliance with these new regulations. First of all, I would like to introduce myself. As you can see from my background here, my name is Leah Owens. I'm the Business Development Specialist here at Bromberg, and I'm also a nationally certified American Sign Language interpreter, which you will see in a little while when I switch with my teammate. So it is a pleasure and privilege to be here today, and I warmly welcome all of you in. Just so everyone knows, we do have our ASL interpreter available. At the bottom of the screen, you should see a little globe icon that it says interpretation. So if you are in need of the ASL interpreter feature, please click on this icon and make sure there is a check mark next to ASL American Sign Language. And you are welcome to also watch the interpreter if you'd like, but that is specifically for those who might be needing sign language interpreting services, which we are happy to provide here at Bromberg. And if you need any help with anything, please send us a message in the chat. All right, well, it's a pleasure to be here, as I said, and I'm excited to introduce our panelists, Jenny Bromberg and Mr. Bruce Adelson. Thank you very much for being here. So to let you know a little bit more about Jenny, we're waiting for Jenny to come on screen here in just a moment as I introduce her. Hello, Jenny, nice to see you. Jenny started Bromberg & Associates in 1999. Here we are 25 years later, and under her leadership, Bromberg & Associates has grown to become an award-winning, internationally recognized language and technology solutions company. Bromberg is also an ASTM 3130 certified and covers the entire linguistic and cultural spectrum, working in over 200 spoken and signed languages with clients in a variety of industries, both here in the United States and globally as well. This year, Jenny was named a recipient of the 2024 Enterprising Women of the Year Award, a very prestigious awards program that recognizes the world's top women entrepreneurs. And she was also recognized and awarded by NASPO to honor the significant achievements of Bromberg & Associates. Jenny also serves as a board officer of the ALC, the Association of Language Companies. So Jenny, we are very much looking forward to hearing your input on this vital topic and especially seeing how it impacts language access. Now to introduce Mr. Bruce Adelson. Bromberg's compliance expert, Mr. Bruce Adelson, is a former U.S. Department of Justice senior attorney and is nationally recognized for his federal compliance expertise concerning language access plan research and development. During Bruce's federal career, he was responsible for enforcing many federal laws, including the Americans with Disabilities Act, the Voting Rights Act, Title VI of the Civil Rights Act of 1964, and at DOJ, Bruce had responsibility for enforcement and enactment of federal policy. Professor Adelson, as he is also known, is an instructor of family medicine at Georgetown University School of Medicine and adjunct professor of law at University of Pittsburgh School of Law. He teaches implicit bias in healthcare, civil rights, cultural awareness, and organizational culture. Bruce, we're so honored to have you here with us today, and we look forward to being able to benefit from your wealth of knowledge and expertise, and we very much look forward to your insights. So please note that as we proceed through this discussion, we welcome your questions. Please utilize the Q&A feature so that way we can we can answer them in an orderly and systematic way. We greatly appreciate that. And it could potentially be answered during the discussion, but if not, we'll definitely make sure to try to use our time allotted to answer those questions that are in the Q&A. Now we'll turn things over to Jenny to get started. You have our attention.
Thank you so much, Leah. Thank you for the warm introduction. And we're looking forward to the second installment, to the second conversation on Section 1557. As Leah mentioned, we already had a webinar dedicated to this topic in May together with Bruce, and it was a very good, comprehensive discussion. So today I'm looking forward to discussing further, seeing what else has been cooking, and how we can share more information on the final ruling, Section 1557, which is in effect since July 5th. Before we get started, however, I'd like to have a quick one-question poll for our audience to share where they are in their journey with Section 1557. So if we can launch the poll at this point, we can do that. And here it is. It should be on your screens. So we'll give it a minute and see what everybody says. If you can just answer how you feel with regards to Section 1557, if you're familiar, very familiar, somewhat familiar, not familiar at all. I see some people are answering in the chat. Well, thanks for that. If you are not able to answer in the poll, it's fine to answer in the chat and we can look there and appreciate everyone answering. So some people saying not at all, first time. Well, I do see that from the list of our attendees that we actually have a lot of people joining us for the first time. So this might be truly the first time that they're learning about Section 1557. And no worries, we're actually planning to go over the most important points that are impacting both interpreters and translators, so the language industry, as well as the requirements that our consumers of language services will have to comply with at this point. So Bruce, let's maybe start the conversation with an overview of the final ruling iteration with Section 1557. Oh, and here we have the results. Thank you. So somewhat familiar has actually emerged as a top answer with 58%, 18 people answering that. And very familiar is lagging at 19%. So there is still a lot to work on. I'm going to turn it over to you, Bruce, to get us started.
So as Brittany said, I'll give you a brief overview of what these rules actually are, highlight a few sections, but also provide two new updates, legal developments that I think are very significant. So the 1557 rules are the healthcare civil rights regulations of the Affordable Care Act. Affordable Care Act was originally passed in 2012. The first set of regulations was 2016, then 2020, and now we have the final ones that, as Ginny said, became law on July 5th. They're the most comprehensive healthcare civil rights regulations that we've seen before. There are a lot of changes from what had existed previously and some new additions. And in just looking at it broadly, I think that among the most significant are that for the first time, the LEP companions, so the LEP patients, have their own right to language assistance. That has not been the law before. The law previously was that you could provide an interpreter or not, but it's not legally required. Now it is. There are also new notice requirements that require notices to be placed in various places physically in a healthcare facility, in a conspicuous location, and otherwise. And these notices are to inform people of their right to free language assistance and free disability access assistance. It's to be provided in up to 15 languages that are relevant to that particular area. So that's going to be quite a task of itself, just to provide notice. So looking beyond that, there's a very interesting change in the law under machine translations. Previously, the law had said, and the federal agencies had insisted, that all documents provided by a federally funded entity be vetted if they're translated by machines, that they be vetted by qualified human translators. Well, HHS changed that so that now the documents that are considered the most critical, the most important, must have human translators to assure that they're accurate if they've been translated by machine. We're going to be talking a lot about that, including one of the obvious questions, well, what are these documents? Because if you go to the regulation section right now, you will not find anything, any specific name that identifies a document that you'll be required to have a human being check for accuracy. But we will reveal the big secrets later, and we'll give you some examples of what those documents are. There's also a requirement for the first time that telehealth must be accompanied by language access and disability access components, whether it's video remote interpreting or otherwise, for people who are limited English proficient or have communication disabilities. It's important in looking at all of this kind of globally. Many of these changes were informed by what HHS experienced during the COVID pandemic. One of them was that telehealth communications often did not make allowance for people who don't speak English well or people who are deaf. HHS decided to make it really clear that, you know what, you have to. So now you have to. It's part of federal law. There's also a new requirement for training, which we'll get into, for having a 1557 coordinator, which we'll talk about, and then also a new regulation that provides requirements for healthcare and federally subsidized healthcare related entities to ensure that what is defined as patient care support devices do not discriminate based on race, color, language, disability, for example. There are many things that are included in this definition, including flowcharts, equations. Now, the equation isn't defined, so we can find an equation in all kinds of things. That really goes to the depth of where HHS wants those organizations who get HHS funding to go, to make sure these devices, some of which have been known to discriminate for decades, don't do that anymore. And that is connected to one of the developments that I want to talk about in a moment or two. So these are very comprehensive regulations. One of the things that we decided to do in our webinar today is go into a little deeper dive on certain provisions, like the requirement for human beings to ensure the accuracy of machine translated materials. As I said, well, what are they? So if I were teaching one of my classes now, I'd ask my students, well, go to the section, let's look at it, and I'll put it up on the screen. You won't see anything. And I've read this often enough to know it just ain't there. But as I said, we'll describe where to look and what some examples of some of them are. But before we get into the specifics a little bit, I want to talk about two specific developments since we were last together. One of them was today, or is today. The Food and Drug Administration announced that it would be releasing guidance on pulse oximeters, which is one of those patient care support devices I mentioned, to ensure that they do not discriminate. Now, pulse oximeters is like a textbook example of discriminatory patient care devices. there has been repeated analysis, repeated documentation, and study showing that these devices, which are sleeves that fit over your finger to determine the oxygenation of your blood, discriminate based on race, so that someone whose skin color is darker than mine will have a reading that is different than mine and may show that their blood has less oxygen in it than I do. My blood does, even if that's just not true. This has been going on since I graduated from law school 40 years ago. The fact that it's taken 40 years to go to where we are now and for the FDA to release this guidance, frankly, shows you the power of enforcement. FDA has gotten pushed by the Office for Civil Rights, which is in charge of enforcing these regulations, as well as the attorneys general from some states expressing concern about the discriminatory history of these pulse oximeters. So that's the number one. Number two is a little bit, I'm going to try not to be too legalism-y in discussing this. This is related to a Supreme Court decision that came out earlier this month. The case is called the Loper-Bright case. It overruled something called Chevron deference. And what that means is the Chevron rule said that if a statute is ambiguous, then the courts must defer to the expertise of federal agencies in interpreting this law. But the key word is ambiguous, meaning that it's just not clear from a plain reading of the law. What exactly does it mean? Well, also earlier this month, a federal court in Mississippi entered a nationwide injunction against 1557's provisions about discrimination based on gender identity and sexual orientation. And I think one or two other courts did the same thing. But what was interesting to me is there's a lot of talk, justifiably, about what this Loper-Bright decision is going to mean. It's going to mean a lot of things, including lots more court cases to monitor and figure out. This Mississippi court decided that the 1557 regulations and the Affordable Care Act are ambiguous. So the court could step in and say, you know what? I'm not going to listen to what HHS said. I'm making my own determination that the statute doesn't give you the right, HHS, to say that you can prohibit discrimination against someone who's transgender. That's incorrect. The court, I think, if you read the opinion, the judge was very eager to be one of the first judges to say, hey, I get to use this new decision and I don't have to defer to what the agencies tell me anymore. That's not true. The only way the court really can do that under this Supreme Court case is if the statute is ambiguous. The Affordable Care Act is not ambiguous about this. It allows the HHS to put out regulations to implement the law. And it also refers to the 6, what I call ancestral laws that the Affordable Care Act is based on. So that if under one of these laws, a determination is made that those laws' prohibitions on sex discrimination include gender identity and sexual orientation, well, we, HHS, can pick that up and incorporate it. Judge said, no, you can't. I have to say, Judge, you're incorrect. They could do that. I understand that the judge and HHS, I think I view this as a difference in legal interpretation, but another clue in the opinion. The judge said that the definition that the inclusion of sex discrimination in one of these underlying statutes must be viewed in the way it was viewed 30, 40, 50, 60, 70 years ago when the statute was written. That is legally incorrect. The Supreme Court, in expanding sex discrimination a few years ago, said, no, it doesn't matter what the people who drafted the law thought sex discrimination meant. What is important is the plain meaning of the word sex and sex discrimination. So, no, we don't have to wait anymore, Ginny, to see what the Supreme Court's decision is going to mean with 1557. there are going to be a lot more decisions on a lot of different topics across lots of fields. That's going to include healthcare. So remember, please, that there is an injunction against the enforcement and implementation by HHS of the gender discrimination and gender identity discrimination and sexual orientation section. That injunction only applies to HHS. It doesn't apply to individual hospitals or doctors' offices because guess what? They are not part of this case. This case is about HHS. So those are my two quick new developments. Overview of what the regulations were all about. As Ginny said, they became law on July 5th, with the exception of this Mississippi court order. Everything else is the law. So, Ginny, are there areas that you want to get into for me to get into now in more detail, or should
Absolutely.
we? Okay, all right.
Absolutely, Bruce. But let me ask you one question first, because
Sure.
I think that we got that question last time. I expect that we would get it again this time. So kind of let's jump ahead. This is what I would like to discuss. So obviously we're in the election year, and we don't know what the outcome would be. So we know that the administration, if there is an administration change, that their view on Section 1557 may be different. And I recall last time we had someone asking, well, why should we implement if there might be a change in administration? What would you say to that?
Might be, maybe, I agree that, yeah, there might be a change. We don't know that. But what if there isn't a change? You haven't done anything. And what if HHS decides to do some enforcement against you next month because you haven't implemented 1557? That's really not a wise course when it comes to risk management or legal compliance. And then also, this is going to depend on the organizational culture of individual entities. If you're not going to implement this, then you're going to further discriminate against people. Are there other ways that people might be able to raise that as an issue? Yes. But then also looking across the board at how you provide patient care and the communities in which you operate, these regulations are very much oriented to healthcare equity and alleviating healthcare disparities. So if you decide to not comply with them, yeah, there are going to be some legal risks. Yes, liability. Your insurance company, malpractice carriers won't like that. Plus, then also you wonder, well, then are you really serving the larger community? When it comes to language, spoken language, the census from 2020 is already out of date because there are more people in the United States now. They come from more countries and speak more languages. And I'd reiterate what I know I've said before, that the United States has people from more countries than any other country in the world. So that hasn't stopped. It's not going to stop. And the needs of people in your community are there now, no matter what happens in the election in November, and no matter what happens going forward. But you're right, Ginny, that different administrations have different priorities. So this is the law. This is not something that can be wiped away with the stroke of a pen. There's a process to making changes, for example. But the law is the law, and the law does allow people to sue if they feel they've been discriminated against. So I don't base my legal opinions or advice based on which administration runs the federal government. If a law has been passed and enacted into law, and there are regulations that are also law, it's the law. So there's a tremendous risk of not complying, and also as well as the issues of healthcare equity that I mentioned too.
Absolutely. And I couldn't agree with you more. It's the law, and it will remain so. And we have to comply with it today as it is. So let's dive a little bit deeper into it. And I would like to start with clinical algorithms, because you mentioned that as something that you would like to discuss further. And that has always been a topic of discussion for us for as long as we've been
Oh, yeah.
having these webinars. Because unfortunately, and even though the needle is moving, it's moving slowly. And the impact of clinical algorithm can be felt even today. So let's talk about that.
Sure, absolutely. I think it's one of the most important parts of the regulations, because the law finally gets at, in a way, the root cause of health inequity, healthcare disparities, or disparate treatment, so that it's very stark if you think about it. That based on the color of your skin only, that readings about your blood oxygenation can be different. That can inform how you're cared for, what medicines you're given, whether you're in some critical care situation. The consequences are almost indefinitely dangerous. I know this has shaken up a lot of healthcare practitioners and providers because they're not sure what to do. One of the more interesting comments in the preamble of the regulations relates to some comments from doctors that they're good with FDA regulation of this area. And the response essentially was that, yeah, FDA does have the authority to approve or disapprove the use of medical devices, but we, meaning the Office for Civil Rights, looks at this from a civil rights perspective, and OCR is the exclusive enforcer of civil rights, healthcare civil rights laws in the health inside of the HHS department. So this is, going back again, 40 years. If you were alive 40 years ago, think about what the world was like. We wouldn't be able to have this conversation we're having today. That's how long some pulse oximeters have treated people differently because of the color of their skin. There are all kinds of requirements for providers as far as due diligence. If they encounter a problem of disparate readings based on race or color, for example, they should be contacting the device manufacturer and asking, do you have any information about this? Because this is what we've discovered. This is what we've learned. And that reminds me, another requirement that I didn't mention before is, for the first time, having rules, plans, procedures, written rules that inform the compliance of an entity with the new regulation. One of them is going to be with pulse oximeters, for example. And just imagine, what do you do if you're a provider and this is happening in real time? Do you base your diagnosis on a device that you know can produce discriminatory results? In law, that's what we call actual knowledge. That means I know personally from my own observation that the device functions incorrectly. No one told me that. I know it. So because I know it, there's a higher standard of responsibility for me to ensure that that doesn't happen again. And in a recent conversation I had with some physicians, we talked about how this is a very important aspect, that with new training, which will be needed, and in some cases in some areas is required, new rules and procedures explaining exactly what you'd have to do, so that if I'm a physician and I'm examining a patient and I get these different readings, do I ignore them? Do I do another test to try to eliminate the disparity? Do I provide care, including medication or other interventions, based on this disparate reading? Of course, there are consequences to each one of these tasks, each one of these responses. This is brand new for healthcare, the requirement of essentially figuring out, okay, well, what do we do now? How do we handle this? Policies, procedures, and plans, PPP for healthcare. That's what you do. And that's going to be a new one, because all the physicians I've talked to, they've told me they don't have any rules about this. they don't have anything. So that's changed now. So if you don't know what a pulse oximeter is, the next time you have a doctor's appointment, ask your doctor if which they should be using on a physical exam for you anyway, to see a pulse oximeter. It's a very simple device. Like I said, it typically just fits over your finger. It's like a sleeve. The reading is almost instantaneous about blood oxygenation. And frankly, if you're concerned about disparate readings because of your race or your skin color, tell your doctor. Advocate for yourself with your doctor so that this mistake doesn't happen to you, because the consequences can be quite serious. And since there is a right to sue under the Affordable Care Act, and this has a potential connection with medical malpractice, I expect that many of my colleagues will be very interested in exploring this aspect of healthcare, since it's well established that there are disparate readings based on skin color, which is illegal under federal law. So I think that, yeah, pulse oximeters I'm watching very carefully, because I think it's a real game changer in many ways, especially since HHS expanded what they're covering under these patient care support devices between the release of the proposed regulations 2 years ago and the current ones, which are now the law. So if that's not a slap in the face showing that, wow, they're taking this really seriously, then I'm not sure what a rhetorical slap in the face would be from a regulatory standpoint. Pretty clear the direction the feds are moving, and it's important to stay ahead of that and insulate yourself from patient care problems, injuries, death, and your own liability.
Thank you, Bruce. Yes, this is very informative. I'm just thinking to myself, I am attending a large healthcare conference next week, and I will definitely have conversations about pulse oximeters and Section 1557 in general. So I'll be sure to share afterwards, and maybe in our updates, upcoming webinars as well. That should be interesting.
I think it would be fascinating. And I think for many providers, I'm not sure what level of awareness they have of these new regulations. So yeah, that will be a very interesting conversation. Tell me and I'll like bug the room you're in so I can leave.
Okay, we'll have to talk about that offline.
Yeah.
But on a serious note, let's talk a little bit about PPP, or what is known as language access plans, policies, and procedures, because that is a new language in the final ruling of Section 1557, expanding a requirement from language access plans to include policies and procedures.
Yeah, exactly. I think that, the expectation that an entity has these policies and procedures and plans has been around for a long time, but they haven't been written specifically into regulations. Now they are. Well, the plans, the policies need to, if you have them right now, they need to incorporate all these changes. And there are a lot of changes that have come. One of the issues too is that between the issuance of these regulations and the last regulations in 2020, website accessibility, for example, for people who are disabled, has really grown in the sense of interest, need, legal requirements, and technology, so that it's easier now to make a website accessible than it was 4, 5, 6 years ago. But that requirement is an important one. That the rules include website accessibility too, just like the last rules did. But what's important is the environment has changed. DOJ issued the first ever regulations on website accessibility, explaining what exactly does that mean. what is compliance with website accessibility. There continue to be a lot of lawsuits and cases in website accessibility. And I hate to burst the bubble for a lot of people, but healthcare providers are tied to the same high level of compliance as local and state governments. Now, that was originally put in the rule 8 years ago, but it's not something that I think people fully understand. You have to do the same as, pick a state, county, or city that they need to do to accommodate people with disabilities. And for website accessibilities, that standard's pretty high. It's higher than for a restaurant or for a hotel, for example. So you don't have the benefit, if you will, of saying anymore, well, there aren't any regulations, and we're just not sure about what to do. But there are regulations. And there's more certainty now about what to do than there was previously. So whatever existing policies, plans, and procedures you have will need to be changed to reflect all of these add-ons and new elements. But what's also true, and a very interesting kind of federal agency speak aside, the regulations say, or the preamble says, that the term language access plan does not have to be at the top of your language access plan or related policy. That if you have already a document that says language access plan, it is compliant, that it includes what it's supposed to include, you don't have to change that and cross it out and say language access policy. It's whatever works for you. So HHS basically said, we don't care what you call things. We care what's in them. So the contents have to be the same as language access requirements have been for a while now. But they don't have to be called plan. If you want to call them language access PPP, be my guest, HHS won't care. They'll care about the contents and the implementation of these plans and policies, and also the training. How do you train people? Because you have to do that now. You're required to do that. That will be at the top of HHS's compliance checklist. So how do you do that? You can't do it in like a 5-minute conversation. If you can imagine what a language access plan should, in my view and in my work, includes, which is a lot of information, how are you going to put that in like a 5-minute onboarding training? The answer is you can't. So figuring out how to do that is a really important aspect here, because it's A, it's new, and B, for the first time, the training must include leadership of the organization and essentially all individuals who have patient care responsibilities or may interact with the public. So the training requirement is much bigger than whatever training has been done previously and will need to be a lot more comprehensive. That's a real good connection between training, plans, policies, and procedures that you'll have to change, and you're also going to have to train on when you launch your first 1557 training module.
Yes, absolutely. I think these are some really great points, Bruce. With regards to web accessibility, there is something that I just want to mention real quick. I feel that while web accessibility requirements have been around for a while, there's still not a lot of awareness of what they are, and especially how they can be implemented, because it seems to be such a daunting task, when in reality it needs to be broken down into manageable pieces and needs to be, again, a plan of implementation.
Yeah, that's a really good point. And when I've worked with clients on web accessibility, you're right, it could be overwhelming. Oh my God, I have 3 billion pages online. What do I have to do? Breaking it down into pieces, looking at the pieces that DOJ has prioritized and the courts have prioritized, and tackling those first. It's not that difficult. to set up a color contrast where you have a light background with darker characters. Makes it easier to read. So that's something that's not, if you have the knowledge technically of how to do that, it's not hard to do. And it doesn't take long to do it. It's not expensive. So I agree completely that there's a new imperative about tackling this. A lot of places have put it off, put it off, put it off. Not now. I mean, you got all kinds of regulations that address this and have requirements. And as our world becomes even more a creature of being online, that includes apps, for example, then there's a strong imperative to get this done correctly. And as an aside, apps must be accessible too. So this isn't just laptop websites. This is apps that you open up, include apps that open up on your phone. They have to be accessible as well. So if yours are not, time to get going with that. One of the first, we talk about plans, policies, and procedures. Having an accessibility plan that explains what you're doing, in what order, and what the timelines are. Courts like to see that, and my friends at DOJ like to see that. And I'm confident that HHS will want to see that. Just explaining when you will do X and when you will be done. Don't say, as one organization once said, we'll have it done in 5 years. And then have the federal agency say, that's too long. You'll have it done in 1 year. And that was a real tough haul for them, because that's a lot to do. But they thought they could play it fast and loose with the Fed and say, we'll just show them 5 years, we'll say that. And they rejected that almost immediately. So realizing that there's a different ball game, so to speak, now, it's time to put those plans into operation and actually have a plan where you explain exactly what you're going to do and when.
Absolutely. With regards to going back to what you said before about training, um, I think that's also a really important topic and could be just like website accessibility could be a separate webinar just dedicated to that. But there are a couple of things that I just wanted to mention. As you know, Bruce, of course, we do training as well at Bromberg and Associates, and we offer training to our clients. We offer training as a standalone service. And I can tell you for a fact that the easiest clients and the most success that we can bring to a client is to have them be conscientious about having training. Because we've seen everything from not knowing how to use VRI. Literally, how do you turn it on? It's a laptop, just like a laptop turns on. How do you use it? Where do you put it? Can a deaf person hold it? No, of course not. Um, and that's on one side of the spectrum. Going to the other side of the spectrum, clients who are proactive about training, who are serious about training, who consider training be an important part of onboarding services, language access services, or just a best practice for their own organization, always have better outcomes because they have internal language access champions and maybe they grow those champions to become language access champions, right? And they also are more intentional about training. It's not a 15-minute short overview. This is how you set a button, this is where you go, and that's it. But they also care about best practices. How do you use language services? How do you work with an interpreter? How do you work with a deaf or hard of hearing person? How do you work with someone who is limited English proficient? What do you do with regards to various modalities? What are the best practices for each modality? They're intentional about content, they allocate time, and they also consider the need for exit assessment tools. And then they have much better outcomes with implementing the training. So it's definitely an important consideration. And I'm so glad that now it is included in Section 1557.
Response anymore that always came from some organizations. Well, we really don't have to do this. Well, Now it's, yeah, you do. And the feds have been emphasizing training, especially DOJ, for many years. That's whether an organization has training is always one of the top 5 questions that the feds raise in an investigation, for example. But I also wanted to touch on briefly that you and I have done trainings together for clients that we're not going to identify, we can't identify today, that really work very well in the sense of explaining the legal requirements, what's happening around the country, why you need to do X, Y, and Z, and then also marrying that to, as you said, well, how do you contact an interpreter? How do you turn the VRI on? How do you make sure the Wi-Fi is working? How do you make sure, do the best you can to address languages that relatively few people speak or that you encounter? So that combination has worked very well because that gives people, I like to say I like the phrase one-stop shopping a lot. So there's one-stop shopping. You get everything you need to at least know how to start so that when people go back to their desks and they get a call about a spoken language or someone who's deaf or someone who needs a wheelchair, they actually have just heard information that informs that. Oh, wait a minute, we just went to that thing earlier today. Now, I will tell you that I recently was involved in a grand round session for a large healthcare system client. And one of the issues that came up by one of the physician presenters was, as you said, people just not knowing how to access devices, how to use them. But also, I was surprised to learn that their focus was on one particular modality, the telephone. They didn't mention video remote interpreting. They didn't mention in-person interpreting. It was almost like they didn't even exist because all they talked about was using the phone, which is not, the number one way, most effective, most useful method of complying with the meaningful access requirement under law. So I was really surprised about that, but that also is reflective, I think, of the lack of full information and knowledge that comes from good required training, so that when they do their required training, they're not just talking about the phone, they're talking about all the ways to provide spoken and disability access to patients. So that really, it struck me, but it really reinforces what you said and the real crying need for solid training so that people don't do what you've experienced and I've experienced, where the doctor says, hey, to the patient, where do you plug this computer in? And do you know where it's stored? Now, if you just think about it, aside from just laughing about it, but then if you stop laughing and think, wait a minute, that person's the patient, and you're asking the patient where the laptop is that is used for video remote interpreting, how is the patient supposed to know where the hospital stores computers? So that is all addressed in good training, and it is a welcome development for organizations too, because I remember that folks were very appreciative of what we were talking about. And they often said, boy, we have never heard this before. This is the first time anyone has mentioned this to us. So the training imperative is a good one to remember, and also a good one to get moving on, to put in place.
And with regards to your story about telephonic interpreting, I'm just reminded of my own. I was speaking with an organization, a transportation organization, that they told me that they only provided telephonic interpreting. And I asked, what about your deaf and hard of hearing? And they said, oh, telephone. I'm like, but how? So that was an interesting conversation. And we had to get into it really for a while to get through that you can't. So it's a basic understanding that is lacking sometimes. So that's why training is so imperative. And another thing that I think is so important and is lacking often with regards to training, it's to keep it repeating, ongoing, refreshers. Organizations have staff turnover, people forget if they don't use something on a regular basis, and we can't blame them. But that's why training needs to be regular, comprehensive, and ongoing.
To say anymore that has to be required because the law says that. And it includes everyone. So that's not really an issue anymore. The issue now is, frankly, organizations putting it together and making sure that they are utilizing folks that their staff will pay attention to and rely upon, because you could put together a training, an in-house training for a whole day. If the program isn't engaging and the speakers are, well, I don't really know the answer to that. That only doesn't, it's not just a question of it not helping, makes things worse, because it tells your staff that you don't really care about this, that you're just doing it to dot an I. But that's not the way this plays out.
Absolutely. Well, I think we need to move on because there are a lot of other things to discuss and unpack. I would like to talk about Section 1557 coordinators, a new position, not a new position, but nevertheless, in the final ruling, it is a requirement.
Yeah, absolutely. I think that what's important is the coordinator's responsible for the compliance of the coordinator's organization with these regulations. So the coordinator, for example, does grievances, keeps records, coordinates the implementation of language access procedure, excuse me, coordinates effective implementation of disability accommodation procedures, coordinates training. So that's a lot to do and imbue in one person, that if that's the way you go, all that authority. But that also brings again the question of, well, what do you do? Who are you going to get to fill these roles? And I've seen the hiring process of coordinators in the past. I've seen what happens when a coordinator is not effective and is not well versed in what the coordinator needs to understand. Boy, can that cause a lot of problems, because that's another question that the feds love to ask. So that making sure you have that good synergetic connection between the coordinator and the training that the coordinator puts together, plus your PPPs, the policies and plans, for example, they all line up together. The only way they're going to work is, in part, that your coordinator understands their role, they understand how to address these issues, and they put together the policies that are needed to do so.
Bruce, we have a question specific to Section 1557 coordinator. And I know we're going to have a Q&A at the end, but since we're talking about coordinators, let's address this question, which is the 1557 coordinator still required after the injunction?
The only thing the injunction covers is the parts of the regulation that concern only gender identity and sexual orientation discrimination. The coordinator, I read what the coordinator's job is. The coordinator doesn't have any direct responsibility for ensuring that people who are transgender are not discriminated against. It's grievances in general, it's record keeping in general. Since there are no records to be kept, since there's an injunction, that doesn't really apply. Language access procedures and procedures for people with disabilities. So that's not connected to the injunction. The only way it would be connected is if you have a patient who's transgender, limited English proficient, and has a disability. then there's two parts of the rules that are not enjoined still come into play. So please remember, the injunctions only cover those provisions of the rule that prohibit discrimination based on a gender orientation, gender identity, and sexual orientation.
Thank you, Bruce. So let's talk for a minute about who would be a good candidate. If an organization, and let's say it's a smaller organization, because we haven't even covered Medicare Part B, right?
Right.
And if it's a smaller organization that has maybe over 15 employees, but nevertheless, it's small relatively, how would they go about finding the right candidate for coordinator position? Who would be that
Yeah,
person?
I mean, that's a tough one. I think that essentially from a starting point, you should have someone who has some basic familiarity or experience with the related issues. That doesn't mean that they're an expert or that they know the specific regulation that covers X, Y, and Z. But to have some experience is always a good thing. Because if you have to educate somebody on all aspects, including what is language access and what does effective communication mean under the Americans with Disabilities Act, you're already starting off behind, because then you're going to have to do more work to get them that basic knowledge that frankly they should have. You may have someone in-house who has some experience with that, but in my experience, it's better to bring someone in, an outside employee, because they won't have the same organizational bias issues that current employees have. They're coming at something fresh. Sure, an in-house person can do the job and do it well, but the number one thing I think is some basic understanding or experience with language access, Title VI, for example, the effective communication, primary consideration rule under the Americans with Disabilities Act, something to build on. Because if you have nothing to build on, you're already a little behind, because it's going to take some time to get up to speed.
And what I would add to that, as someone from the language and industry, as someone who is passionate about language, is you would want someone who is already innate language access champion, someone who cares about this topic, and maybe someone who is from the language industry, because interpreters and translators, we're supposed to know about language access. That's what we do, that's what we deliver. So we could be a good candidate for a position like that.
Absolutely. I think that's a very good point, because that obviously includes someone with a basis of experience and knowledge, so that you can go from there rather than explaining why does an interpreter, and like at that grand round session only talking about the phone. Well, an interpreter knows that language access is provided by more than the phone, so that's already more than what the supposition was at this large healthcare system. So I agree. I think that that's important to as a criterion to evaluate.
Absolutely. Well, let's move on to another large topic, and that is translation. But before we do, I kind of want to jump ahead for a second and launch our second poll just to see what everybody thinks with regards to document translation. So the question is about the documents that could be run through machine translation without any further review. And we'll give it up to a minute for everyone to answer. And I'm really glad to see that 68% of everyone who answered said none of the above. Thank you for that. I know we have a number of interpreters and translators attending the webinar today, so they better know, and they do know. And it's interesting that everybody, well, other answers were split between 14, 7, and 11% saying all of the above, intake forms and discharge instructions, but nobody said consent forms, which I find interesting. So Bruce, can you walk us through what the requirements are today?
May I provide the answer to the question?
Yes, please.
The answer to the question is all of them. Sorry. But that's also an example of how the rule has changed what was the law before. What's interesting, and I know I alluded to this, and now, we'll open up the vault and reveal the secret here. That the specific rule that relates to machine translation does not give you examples of documents that you have to have a human being vet for accuracy. So there's something called in law the whole act rule, which means you take a statute as a whole and interconnect the pieces as needed to come up with a rational, complete meaning or answer with any particular section. That applies here. Because the section that gives you a more than a clue, but something you can hang your compliance hat on, is the provision of about notice. That's 92.10 and 92.11. There's a very good summary which goes back to guidance that HHS issued about 21 years ago that gave some examples of documents that were called at the time vital documents. That term really isn't used in the regulation anymore. They refer to critical and important information. So what would that be? So I'll give you a couple of examples. One of the examples would be consent forms and instructions related to medical procedures or operations, a medical power of attorney, discharge papers, notices of appeal and grievance rights concerning patient care and also healthcare insurance. And let's see, and another one would be complaint forms. So that if you have a complaint about how you've been treated, you think you've been discriminated against, that has to be translated. So the answer is, to the poll, all of them. And that answer comes from the section involving notices. Now, in our May webinar, or in our May webinar?
May.
We talked about HHS specifically refers to the fact that past information past guidance, advisories, opinion letters are still valid and may well provide, and I would take out the words may well, do provide information related to compliance with the new rules. That's why this is very complicated and very complex. I've run into a lot of in-house general counsels in hospitals who say, I don't really know what the answer is to this. Or if we talk about, well, if you go back to DOJ's guidance in 2002, their response was, their what? When did that come out? And you're telling me that it's been X number of years since this document was released or published that has information concerning my hospital's compliance? Yeah, it does. So that's why I'm also very keen to do the webinars we've done and other things that we're going to do, just to make sure you all have good, accurate information, because there's a lot of inaccurate, poor information that's out there. And in all the things I've read, I haven't seen anybody say you can get some good answers by looking at the 22-year-old DOJ guidance about LEP language assistance. So the pieces are there. You need to know how to look for them, and you need to know where to find them. So I remember Ginny and I had talked about this shortly after the new rules came out, and we talked specifically about the machine translation part. And the fact that, I've read this over and over again, they don't provide a list of what the documents are. They just kind of, say what's critical and what's important. Well, of course, that's subjective. You could say, directions to the parking lot are important, or something that is just not consistent with the regulation. But again, these are the objective answers. These are the answers that I told you about a few minutes ago that have new notice requirements for them. They also happen to be in documents and materials that provide the most critical and important information for patients who are seeking or obtaining health care. So keep in mind that there are a lot of interactive parts here. And if you really want to do two things, freak people out and impress them, tell them about the whole ACT rule and just watch their reaction when you explain that or say what that means. Pretty confident that most of the people you talk to will be stunned and will want to know more, which is always a good thing.
Bruce, just to clarify, I think with regards to this question, and we do have a question in the Q&A about it. Though the documents that were listed, consent form and take consent forms and take instructions, discharge instructions, those would need to have a human in the loop because they are important enough to be reviewed by a human.
Yeah,
Correct?
exactly. Yes,
So,
remember
okay.
the rule says
Yes.
you can use machine translations for anything, but for the documents that provide the most critical and important information, you must have a qualified human translator, and I accent the word qualified, to review the machine translations for accuracy. So just putting discharge instructions through a machine translation and not having a human being ensure accuracy, I guarantee the document will be inaccurate in some way. And these are the instructions you're giving to patients on discharge about medication and care they need to provide themselves. You don't want to mess that up because that has been messed up with people who were LEP previously, and the consequences have been severe. So yes, Jenny, that's a good point, that these are all the documents that are provide the critical and important information that HHS talked about in the regulations. So now we've given you the secret to what are they specifically. So if your supervisor, your CEO, your CMO says, yeah, okay, well, where do I find the answer? 92.10 and 92.11, the list of documents that you have new notice requirements for, the same types of documents that apply to the human vetting of machine translation.
Thanks for the clarification, Bruce. One thing that I do want to mention is that in all the years, we're a language company, and all the years that we've been working with clients, we've seen a number of documents being run through machine translation. And for the most part, machine translation is Google Translate because that's what everybody knows and everybody, well, some people utilize thinking that it's a good solution for their content. And I've never seen a consent form, a discharge form, intake, any sort of an important document, anything beyond just a basic, very, very basic. And even then, there are caveats to what could potentially be basic email exchanges that were run through Google Translate and came out with flying colors. Of course, it depends on the language and the content, but 90% out of 100, even with the most top volume languages, Spanish, for example, it comes out to so bad that it does need to be retranslated. And lately, I mean, obviously with AI, with introduction of LLMs, and with AI and machine translation becoming more and more sophisticated, the challenge is that sometimes for someone who is not a trained translator, it may look good enough. And that is really dangerous because good enough could contain really serious and concerning mistakes. It may not have clear mistranslations, but it may have some that could have very negative outcomes. Similar to what actually happened in 2021 in Virginia, right, Bruce? Where Virginia Health Department had a translation on their website that was done through Google Translate that said that COVID vaccine was not necessary, where they meant to say it was not required. And they ran it through Google Translate and it looked good enough. But what a big difference.
That's a great example. The Google Translate and other machine translations are not to the point technologically where you are virtually guaranteed to get an accurate translation. And particularly, as you know, Ginny, that the more complex the document, the longer the document, the likelier it is that there will be errors. That's true in any language. It's truer in languages that are less common. There have also been court decisions that are very critical of the use of Google Translate and explain what the inaccuracies are. And there was one court decision, might have been about four years ago, in Pennsylvania, where the judge just slammed the use of Google Translate and said that these are replete with significant mistakes. They're not trivial. These can go to matters of life, death, and safety. So yes, it makes it clear that for the most important part, I think that is what HHS is emphasizing. The most important things must be reviewed by a qualified human being, period. If they're not among the most important things, they don't have to be. So that's a very important consideration here. It is a big change in the law regarding machine translations, and it's something to be very much on top of, since it's easy, and I've seen regularly physicians at bedside use Google Translate or whatever they use it for, or take a picture of a document or have a scanned document that is then run through machine translation. Oh yeah, you can send all these procedures. Here's the translation. No way. No way. Not without having a qualified human being review for accuracy. Can't do that. I know it's easy. We both know where everybody's so used to using apps in the computer for virtually everything. Not this. You need to have that human being. That's what the law requires. And that's something that I'm very confident will be coming up in enforcement and in court.
Absolutely. And one more point. So machine translation is different from LLM. So it is really important to remember that aspect. LLM are new. We can do a whole webinar just on that. So we're not going to spend time on it today. But when we're talking about machine translation, it is a tool. And it's a tool in hands of professional translators who know which engine, which machine translation is good for a certain language, how Chinese would be different from Ukrainian, from Spanish, and whatnot. Languages of lesser diffusion, there is not enough corpora, there is not enough content to even use machine translation with a lot of them, just because they're smaller and there haven't been enough content generated to train machine translation, to be able to get to a point where it's even possible to have a human in the loop. Otherwise, it all needs to be scrapped and redone.
Exactly. And I would also add to that the people who are doing the translations, the companies that have experience, of course, they're not all equal. And I think that what's also important to remember too, the easy isn't the right. The easy isn't the compliant way. It's certainly not anymore. And unlike a judge I was told about in a large Midwestern state, who was eager to use AI for many aspects of court operations, including language assistance. Have it up and ready. And the chief judge asked the IT manager, so when will this be done? This conversation was just earlier this year. And the IT manager said, oh, Judge, we'll have this up in 6 months. We'll be able to use machine translations for everything. And whether that's in court, healthcare, education, law enforcement, transportation, the same rules apply. That if you're relying on a machine solely to translate important information, you are leaving yourself wide open to all kinds of problems.
Absolutely. And I think that's where companies considering, or organizations rather, considering the use of machine translation, again, need to have their language access champions involved in the conversation.
Oh, absolutely. I totally agree.
The outcomes will be quite different.
It will be.
Yeah. Bruce, I know we can continue for a while, but we have only 12 minutes left before the allotted time expires. So I wanted to take some questions, and we have a few in the Q&A. So I wanted to ask, start with, can you elaborate more on bilingual clinicians? If clinicians have obtained higher education in their home country and can provide proof, does that make them a qualified bilingual clinician?
The term qualified bilingual clinician isn't really a legal term. I know that's a term of practice. And the short answer is no, that anyone who's providing language assistance to someone who's LEP must be assessed for their language ability by the organization that employs them. Now, assessment of language ability concerns English, the target language, but most importantly, medical terminology. Now, this came up in the grand rounds presentation, where there were a lot of questions about, well, how were interpreters trained? Are they trained on what appendicitis is? Which I thought was really interesting, is the consensus from the audience was, no, they don't know anything about this. And that, as an aside, that's a good advocacy educational piece for all of you interpreters and translators out there, to be organized about, to educate providers on your background, what you have to go through as far as your training, because they don't know. It's a very simple rule in a way, but I know it gets complicated in implementation. If you provide language assistance in a federally funded facility to someone who's limited English proficient, your own language ability must be assessed, and it must be proven and determined that you are proficient or fluent in the two languages, English, target language, and in medical terminology.
Exactly. And when I was thinking about this question, the answer that was coming to my mind is everybody needs to go through language proficiency testing. Someone might be trained in their home country 30 years ago and not necessarily communicate in their native language while they live in the US. So their level of proficiency will go down, and languages evolve. The way we spoke 30 years ago is different than we speak right now.
Yes,
we have so many more new terms to remember.
Great point, Jenny. And I added to that, I would say that all the physicians that I've done education programs with, if they're non-native English speakers, most of them have said exactly the same thing. When I was in school, I wasn't told what the meaning was of these terms. I'm still not necessarily clear on, all the appropriate words to use to describe a procedure in my native language. So I'm going to get assessed, or I'm not going to be the interpreter anymore. I'm going to defer to somebody who is a professional interpreter who has the qualifications and the training. So there's always been a real wake up, and I've had so many come up to me and say, you're absolutely right. I wasn't taught this. I don't know that. Whereas, as you said, Jenny, I haven't spoken my language in however many years. I'm just not up to speed anymore.
Agreed. Okay, next question. What do you anticipate will be the estimated financial cost for an organization to come into compliance with these Section 1557 regulations? Would it would be helpful to see some potential budget templates shared?
Well, I can't share any budget templates with you, and I couldn't give you a general estimate of cost without knowing more about your organization. But as we all know, there have been a lot of best practices that have been implemented by many different organizations, by their language service partners over the years. And those best practices are available for duplication up to a point, let's say.
Looks like,
So,
oh, your audio, you're back. You froze for a second.
okay. So having more than one language access company provide language services for you, that's a very important best practice, because if their phone lines go down, their power goes out, how do you contact them? You can't tell the patient, well, we only have one company and they're not available to. So having redundancy is one example of a best practice that has been proven to be very, very effective. So that, I know that's not the total answer that you want, but that's really, I think, as far as we could go publicly today. I know we're certainly happy to answer that question offline in more specifics. But there are ways that you can effectively manage your cost with what's already out there.
And you can also ask your language company that you work with what their redundancies are,
Mhm.
because a good language company will have redundancies. If the main call center goes down, there has to be a backup.
Mhm.
Okay, next question. Are there recommended language proficiency assessment tools and interpreting skills assessment that can provide objective measurements of bilingual staff or interpreters? Well, I feel like this is Jeannie question, and if you want to reach out to me offline, please do. I'll be happy to answer this question in more depth. But yes, there are. There are a number of companies in the spirit of full disclosure, our second company, Linguist Education Online, does that for bilingual staff and for people who are either planning to interpret or already interpreting, both testing and training. Besides us, there are other organizations that do that as well. So you can compare what is most fitting for you. And I'm happy to answer any additional questions with regards to this later on. And I think we can do maybe one more question real quick. What is considered good and bad machine translation? Where does AI fit in? Thank you for that question. Good, I guess, Bruce, I should start with this one as well. Good and bad machine translation is really, first of all, it needs to be assessed by a professional. Of course, what is publicly available, what is free, will much more likely not be good. There is a old adage that goes, you get what you paid for. So if you are using a free machine translation publicly available to translate sensitive documents, it is a bad machine translation, guaranteed. If your language is not top volume language, it's a smaller language, then it's even much more likely to be that. So I think it's, again, back to what I said a few minutes ago, it is a tool and it needs to be used as such and assessed by language industry professionals. Bruce, anything else?
I had one quick example of a bad machine translation. This was in discharge instructions. And this is a true story where the physician had prescribed a certain medication, take once every 4 hours. The translation by the machine was take one dosage every 4 days. The patient did that, became comatose, critical condition, he almost died. So that is a true life example. There are many other examples of complex text that is just not, it's translated into gobbledygook. One way to look at it too, everybody knows in criminal law, the Miranda warnings, you have the right to an attorney. Put that through Google Translate, see what you come up with. Because in courts have said this makes no sense when the Miranda warnings are translated by machine in these particular cases. You get that one wrong, and that gives the person who's accused an opportunity to raise that as a significant defense to their prosecution. So those are some very clear, true stories of bad translation.
Well, thank you so much, Bruce. We'll do the last poll real quick and then turn it over to Leah to close us off for the day. But this was a great discussion. And if we can have the last poll to go through. By the way, if we have any open questions, we'll be happy to answer them after the webinar. So everything that we didn't get a chance to answer, we'll be happy to respond to afterwards. So feel free to reach out to us with any questions. So the last question, last poll question is, what do you see your biggest challenges in implementing new requirements? Cost, staff training, ensuring compliance, or other? And cost and ensuring compliance are so far almost neck and neck. Well, ensuring compliance is, yes, I think that's going to be potentially the top answer. Yes, I think we can close the poll with ensuring compliance being the top answer. Well, if you have any questions about that, please reach out to myself or Bruce and we'll be happy to help. And with that, thank you, Bruce. I'm going to turn it over to Leah.
Thank you, Jenny.
Bruce, Jenny, thank you so much for this information. It's definitely a lot to unpack, but we did it. That's why we actually extended today's webinar a little more, because we knew this is a very vital topic and there is a lot to discuss. So thank you for that. Just a few quick highlights. We talked about the importance of not putting off the implementation of Section 1557. We talked about healthcare equity, accessibility, training, how to use services, when it is appropriate and not appropriate to use machine translation. All of this was truly critical information. And again, anyone is welcome to email me. I put it in the chat. Jenny, Bruce, we're happy to get you in touch with Bruce. If there's legal questions that we're not qualified to answer, we of course will refer to his expertise on those matters. So we're happy to be a resource for you and to share whatever information we can to help this implementation be as smooth as possible. So thank you all for joining us, and we appreciate it very much. And we hope that you all have a great day. We'll see you soon.
Bye.
Thank you.
Thank you so much.
Thank you. Bye-bye.
Bye.